Another common example would be property received as a gift or an inheritance. Inheritances are fairly easy to prove. Normally there's court documents that define the separate property asset. So they're fairly easy to prove. However, that doesn't mean it's easy to trace them necessarily. I'll talk about tracing here in a minute. But it's easy to show that at least at inception it was separate property. So inheritances are separate property. Gifts are also separate property. And when I say gifts, that can mean everything from your parents giving you a cash gift, or it can be, for example, a husband buying wife a diamond necklace for her birthday. That would be an example of a gift, and that is separate property just as much as any other separate property asset. And the last one is relatively rare and somewhat complicated. There's certain kinds of personal injury recoveries that are separate property. There's certain elements of the recovery that are separate property, and there's certain elements that are not separate property. That's a more complicated issue and probably could be a webinar all on its own. But like I said, it's a fairly rare issue, so we're not going to address it here. So here's some important facts about separate property. First, there is a heavy burden of proof on the party claiming the separate property. In other words, it's not enough to just say, well, that's my separate property. It's the burden of proof on the person who's claiming it as separate property. And the burden of proof is called clear and convincing. Now, this is a different standard of proof than the usual preponderance of evidence standard, and it's a heavier burden of proof. So the bottom line is, if you're going to prove your separate property claim, you need to be able to show by clear and convincing evidence that you can trace the asset all the way back to time of marriage. So like I said, that can be very easy with certain assets. For example, the house that you still own, that's an easy one. You just show the deed. It can be much, much more complicated and much more difficult to prove if you consider the example I gave earlier about the financial account that had transactions going in and going out. That's not to say that if there's been some commingling of separate and community assets that it's impossible to trace back your separate property. It's just much more difficult. Often it's sometimes required that a CPA be hired as an expert witness, and the CPA does what's called a tracing, and they do an analysis and they report and show exactly what they believe is separate property, and they do that by literally analyzing each transaction in the account or accounts. So it can be somewhat complicated, but depending on the value of the separate property asset, it is sometimes very worthwhile. So I talked a little bit about examples already. Easy example would be the real estate that was owned pre-marriage and still owned at divorce. Much harder example is the financial account that we talked about, where the investment account had deposits made after marriage, withdrawals made, securities bought, securities sold, income from the securities such as dividends were paid into the account. That's community property. Interest off of cash put into the account or redeposited into the account. All of those things make the separate property more complicated to trace, but it's still usually possible for a good financial expert. So the bottom line to separate property is that if you're getting divorced and you have a significant separate property claim, you really want a good divorce attorney who's going to analyze that and potentially even hire an expert. My view on it is you don't want to immediately hire an expert. Often you can trace the asset through the records that you have, but if you have to go to court and you have a significant separate property claim, you probably will need an expert, but absolutely you need a good family law attorney. Let me tell one brief story about a case I had that made a significant difference in the outcome because of a separate property claim. The client was a gentleman who worked for probably 30 or 40 years for one of the major oil companies. He had one of these ESOPs, an employee stock option plan, and he bought stock in the company and had, at the time of marriage, owned some stock in the oil company, big public company. And at the time of marriage, it wasn't worth very much. It was about $10,000 worth of stock. But he kept that stock all through the marriage, and then I believe 25 years later, at the time of divorce, that stock had grown in value to more than $300,000. Not through additional purchases. I'm talking about just the shares that he owned pre-marriage. So wife's argument was, well, $10,000 of it is his separate property. The rest is community property. And that sometimes is the way that it gets analyzed. However, there's a lot of case law support to show that, at least with stock, the actual shares of stock are what the community property is. So if you own 100 shares of stock at time of marriage and you own the same 100 shares of stock at the time of divorce, well, those 100 shares of stock are your separate property. And the fact that the value of those 100 shares of stock went from $10,000 to $300,000, that's not income. And the significance there is that income off of separate property is community property. So there's a long string of case law that says stock value appreciation is not income. So in his case, as I said, the outcome was significantly different because we were able to take $300,000 out of the community pie and basically set that aside for him as his separate property, which made a big, big difference in the overall outcome.